planning balance exercise, yes?
Well, I submit that the evidence that I produced in my proof evidence goes to demonstrate that the proposal is unacceptable in planning terms for the reasons set out. I don't see the necessity to go, I didn't see the necessity and don't see the necessity to go beyond that in terms of my evidence. I've covered all the issues. The planning balance emerges from that, but I don't think it needs rehearsing as such in terms of my evidence.
Let's take that in stages. I think I have at least an implicit confirmation in that answer that the proof does not contain, does it, an attempt to look at the material planning considerations globally and undertake a planning balance. You say we should simply read your proof and infer from that what your conclusion as to the acceptability of the proposal is, yes?
Yes.
Yes. Now, you are the only person who has provided a proof of evidence on behalf of the Rule 6 party, yes?
Yes.
Yeah. And to be clear, you have given evidence not as a member of the public, but in your capacity as a chartered town planner, yes?
That's correct.
Yeah. And indeed, in paragraph 1.2 of your proof, you state that the evidence that you've given accords with the guidance of your professional institution, yes?
Yes.
And I assume that as a chartered planner, you would mean by that the RTPI, yes?
That's correct.
Yeah. Now, you will be familiar, of course, because of your experience, with your duties as an expert witness, yes?
Absolutely.
Are you familiar with one of those duties being to provide, and I quote, expert unbiased opinion in relation to matters within your expertise?
Yes.
Yes. Can we agree that an essential part of the exercise of providing unbiased opinion on a planning proposal is to identify any factors weighing in favour of granting planning permission, any factors weighing against the grant of planning permission, and then make a fair, independent judgment on whether the planning balance comes down for or against the proposal? Can we agree that's an essential part of the exercise of providing an unbiased opinion on a planning proposal?
I've given an unbiased opinion on all the issues which I think are relevant to the consideration of this application. I find nothing to weigh in favour of it other than the provision of 430 houses. So that we could labour the point on putting in a paragraph about the planning balance, but I see no necessity to do that because I think the evidence I've given demonstrates the position which for the Rule 6 party we have adopted, and my evidence is comprehensive. I don't see any omission that falls foul of my obligation to give unbiased evidence. I've given unbiased evidence on all the issues that have been identified in my proof of evidence. If I'd found there was something in favour of this development, other than the fact that it provides 430 houses, I think I would have pointed it out. But I find that hardly necessary because it's a self-evident situation that flows from my proof.
You mentioned the provision of 400 plus units as one benefit of the proposal. You mentioned that in your answer, but I have read your proof of evidence several times, Mr. Yarwood, with great care, I can assure you. I have not been able to identify a single statement in your proof of evidence that acknowledges any of the benefits that this proposal will deliver, including the provision of housing. I'm right on that, aren't I?
You are, yes.
Yeah. So there won't be any acknowledgement, will there, in your proof of the benefit of the scheme delivering well over 400 houses in a district that has a housing land supply of only 1.36 years, will I?
You will find that I've covered that point largely in my section on affordable housing. It seems to me that a proposal that does not deliver affordable housing has no great benefit, even if it delivers 430 houses. I can't see any other benefit. I could have put in a paragraph at the end which said there are 430 houses here, and the district council has a very low level of 5-year supply. That's self-evident. I don't deny that. I don't feel the need to express that in my proof of evidence. It doesn't seem to me to weigh heavily in favour of the development, but no doubt your witness will claim it is, and I will cross-examine him on that. But I've given a comprehensive view of my opinions on the issues which I think are raised by this application. I apologise if you think I should have made a brief statement about its contribution of 430 houses. I'm happy to say that is the benefit of this scheme, but I don't see it as a great benefit in terms of outweighing the disadvantages.
You certainly don't need to apologise for any of the evidence that you've given, Mr. Yarwood. All I'm simply seeking to do is to test whether you have, as you purport to have claimed at the start of your proof, whether this can fairly be said to be an unbiased expression of independent opinion by a professional planning expert looking at the issues objectively, or is it something other than that? And you referred to section 6 of your proof of evidence, which was dealing with affordable housing, suggesting there, as I understand it, that we will find either explicitly or implicitly in this section some consideration of the benefit of delivering 400 plus units on this site in a district with an extremely low housing land supply. Again, I've read section 6 again since you gave that answer. I will not find, will I, any consideration of that benefit either explicitly or implicitly in that section, which is focused only on your concerns in relation to affordable housing. Yes?
That's correct.
Yeah.
It can be. I think it is implicit in a sense that since I'm criticising the level of housing provision lacking affordable housing, that it is implicit that is my concern about the provision of housing here. But if you can point to anything anywhere in my statement that you think falls foul of my requirement to be unbiased, I'd be interested to hear it, because every single word of my statement is my unbiased opinion.
Yeah. I am, with respect to you, making that point to you and making that contention to you that the evidence is not genuinely an objective and independent appraisal of the scheme, because it's simply not credible, is it, Mr. Yarwood? In a proof that focuses only on what you consider to be the factors weighing against the grant of planning permission, a proof that ignores any of the factors weighing in favour, you cannot, with respect, credibly claim to have acted as an unbiased expert if you've only focused on one side of the debate.
Well, I disagree entirely with you. In my experience, which is fairly considerable, the appellant's case is the appellant's case for refusal. That is what I've put forward.
Isn't the
Sorry,
reality?
The appellant. The Rule 6 party's case is that this shouldn't be refused. I've put forward that case. I don't need to put forward the case for the appellant. The appellant will put forward the case for the appellant. I put forward the case for the Rule 6 party. It's an unbiased case because every word that I've put in that case is my professional unbiased opinion.
But that answer's quite telling, isn't it, with respect? You understood your function, did you, to present a case in evidence not to provide evidence that might be in alignment with the case and based on your independent objective opinions, but you actually did consider it to be your function to argue a case for the Rule 6 party. Is that right?
I consider it my duty to look at the case that the Rule 6 party wished to present, and to the degree that I could accept that case, present evidence on behalf of the Rule 6 party.
That's a rather curious, I suggest to you, understanding of your function as an expert. Your function as an expert, I suggest to you, was to, of course, take on board the Rule 6 party's case as you understood it to be. They come to you as an expert and ask you, are you able to support the case that's being argued by the Rule 6 party? Your function then, I suggest to you, was to come to a judgment as to whether your independent opinions aligned or were consistent with the Rule 6 party. But your function wasn't to decide on the extent to which you could accept their case, was it? Again, that's rather telling of your understanding of your function.
My function was to make a judgment about this planning application on its planning merits. That is what I've done. I've raised the concerns which I think are legitimate. You will recall that our position at the outset was to support the refusal of this application, which had been recommended and decided by the council. At that point, my role in representing the Rule 6 party was to support the reasons put forward by the council for refusal of permission. That is the position from which we started. We were left later on with a position where we had to defend those reasons without simply backing the council, but by presenting the evidence ourselves. At that point, we needed to look at the planning issues in some detail, and I had to make a conclusion about the merits of this application. I could find little merit in this application, and I found a lot to count against it. That's the evidence I've presented. It's unbiased, and it's balanced in that sense.
Yeah. It's not balanced, you see, because balance implies a consideration of competing arguments and competing considerations.
Well,
Isn't the reality? I'll put the question and then you can come back, and this will be my last question on this section of the cross-examination. Isn't the reality here, Mr. Yarwood, that because of that lack of balanced consideration, you've not, in fact, have you, on a fair reading of your proof of evidence, provided us with an expert planning appraisal of the proposal? What you've really prepared with respect is an advocate's statement that's simply presenting a one-sided case against the proposal, yes?
No. What I've done is, in relation to each and every individual issue which I've looked at, come to a conclusion about the, if you like, the planning balance on that particular issue. I've weighed the evidence that I've seen in this planning application on the very range of issues which have been raised, and I've reached a professional judgment on the balance on each of those issues. And on none of them have I found the balance in favour of the appellant. This is how I've seen it and how I've recorded it. I simply do not accept what you say, that I've not made a balanced judgment on relation of each of the issues which I've addressed in this statement. And I don't think I've omitted any issues either. I think I've looked at all the key issues and I've reached a professional judgment about the merits of the application on each of those issues.
I have to pick up on one aspect of that answer, which is that you do understand, don't you, that when we refer to a planning balance, what we mean is a balancing of all of the relevant considerations as part of a global assessment. It's not meaningful, is it, to talk about a planning balance carried out internally in relation to one particular issue, which seemed to be the answer that you've just given me. You understand that's not what we mean professionally when we talk about a planning balance. It's not about planning balance within an individual issue. It's about a planning balance of all relevant considerations, which might be competing, yes?
Yes, it is. That's correct. But as I've said before, I don't believe it's in my remit or necessary for me to present an argument in favour of the appellant's case. The appellant will do that. I maintain that what I've presented is a professional judgment on each of the issues which I've looked at. You may say, well, at some point I should have looked at the benefit of this scheme and weighed that in the balance. That would have required a simple paragraph saying this presents 450 houses. I do not think that outweighs the disadvantages. I apologise if you think I should have said that and didn't, but I think it's self-evident that the only balance to be weighed in favour of the appellant's case is the provision of 450 houses. I fully accept that. What I do not accept is that outweighs the judgments I've made on all the issues which weigh against the proposal.
Yeah. It's a little more than that, you see. You say, well, it would only have been a matter of adding a couple of sentences, a short paragraph, carrying out that simple planning balance. Except it's not, isn't it? Is it? You don't dispute the fact, Mr. Yarwood, that the council only has a 1.36-year housing land supply, yes?
I don't dispute that, no.
You will know, again, because of your experience, that, of course, triggers, doesn't it, the application of the tilted balance under paragraph 11 of the framework, yes?
Yes, but it's not. You don't need that in this case because the site is allocated. So you yourself have said that that whilst the tilted balance is engaged here, it doesn't really count much either way because this is an allocated site. Even if the tilted balance hadn't been engaged, you benefit from the fact it's an allocated site.
Yes, that's our case. But let's just work through together, please, what the tilted balance means for your case. As you rightly stated, the appellant's case is that it doesn't need to rely on the tilted balance because this is, we say, a proposal that complies with the development plan as a whole. Now, clearly, that's not your view. Your case is that the proposal breaches some development plan policies. You're not explicit about that in your proof, but I think we can take that implicitly as being the implication of your evidence is that you say that the proposal breaches development plan policies relevant to the issues of concern to you and as cited in the council's original reasons for refusal. That being so, Mr. Yarwood, I will not find, will I, any consideration in your proof of whether the development plan policy breaches that you contend would take place mean that the proposal doesn't comply with the development plan as a whole. I won't find any consideration of that question, will I, in your proof, because you have provided evidence solely on this issue by issue basis, yes?
Yes.
Yeah. So we won't find that consideration in your proof. What we won't find either is any acknowledgement by you that the tilted balance applies in this case, doesn't it? In the event of the decision maker concluding that the proposal doesn't comply with the development plan, which presumably is your case. Yes?
As I've said, I don't think that either you or I need to engage with the tilted balance because the site is allocated. If you say, right, let's look at the tilted balance. The tilted balance merely means that you can effectively ignore the restrictive housing policies which would otherwise engage. You don't need to do that because this is allocated anyway. So the housing policies support your case. Therefore, the issue which arises here is whether the development is compliant with housing policies, it is, and therefore you don't need to engage the tilted balance. The question arises here is whether the adverse impacts of this development outweigh the benefits. My judgment is that they do, that the case that I've put forward for refusal is compelling and outweighs the fact that this site has been allocated in the local plan. Your tilted balance may in some ways add to that. I don't think it adds much because, as I say, the tilted balance tends to be used to override restrictive housing policies rather than to look at fundamental objections which contravene other policies of the local plan.
Forgive me, Mr. Yarwood, I'm not following that with respect. It seems to me, and I suggest to you, you can't have it both ways, can you? You can't say on the one hand, well, look, you don't need to look at the tilted balance because we're relying on the allocation. And then to say, well, tilted balance doesn't really add anything here because it is the appellant's case that we are compliant with the development plan. You have got to work out, haven't you, if you're purporting to give independent planning evidence as a planning witness on behalf of the Rule 6 party, you've got to work out, haven't you, the implications of your position, which presumably is that you would consider the proposal to be in breach of the development plan, yes? Not that you spell that out, but I must infer from the evidence that you give that must be your position, that the proposal doesn't comply with the development plan, and so therefore we are not able, you say, to rely on that first bit of the presumption, hence the tilted balance, yes?
In looking at any development, one looks at the local plan as a whole. Right.
Yes.
And if something falls foul of certain policies, that isn't overriding by complying with others. Right.
Forgive me. I think we need to be clear on this because it's not something that you have dealt with in your proof. Let me ask a really simple question. Is it or is it not your case that the proposal complies with the development plan as a whole?
It's my case that it does not.
It does not comply, right? Let's work that through. If it's your case that the proposal does not comply with the development plan as a whole, you will know as an expert planner that in a case where we don't have a 5-year housing land supply, we've therefore got to work through, haven't we, the implications of that in terms of the planning of the tilted balance within the presumption in favour of sustainable development. I will not find, will I, in your proof of evidence, any acknowledgement by you that the tilted balance even applies, let alone any attempt to undertake that tilted balance, will I?
No, I'm sorry, you're right that I haven't referred to the tilted balance for the reasons I've already explained. But yes, I think the tilted balance is a matter which you could have raised in support of your case. It was your choice to argue at the outset that you didn't need to engage the tilted balance, and therefore I haven't concentrated on it or referred to it in my document. But I agree with you entirely that the tilted balance is engaged and that it carries some weight in favour of your proposal. I don't think it outweighs the disadvantages that I've referred to in my proof.
Yes, but in terms of your proof, that is an exercise that we simply won't find within it, will we? And as you know, the tilted balance is not a simple, straightforward, flat balance of weighing the pros against the cons and so forth. It is a more onerous test of asking whether the adverse effects of the proposal significantly and demonstrably outweigh the benefits. And that is simply not an exercise that we will find carried out anywhere in your evidence, despite it being the logical implication of the position you've adopted, is it?
That's correct. But if you want to examine me on that issue, I'm happy to be cross-examined. My position has been very clear. I do not believe that the provision of 450 houses, tilted balance or not, outweighs the very significant and adverse impacts of this development, which I've set out in my proof of evidence. That's my position. I'm sorry I've not been explicit about referring to the tilted balance or the planning balance, but I think it's self-evident from my evidence, that my evidence concludes that this is an unacceptable development which is not outweighed by any careful consideration of the balance of issues.
And the short answer, or the short question that I would ask in response to that, Mr. Yarwood, is it is clearly not self-evident, is it, when you have not sought to ascribe any positive weighting to, for example, the provision of housing. So it's not possible for the reader to understand from your evidence what the outcome of that tilted balance would be, because you're simply silent in your proof on what degree of positive weighting you would give to that provision of housing in a context of this district having a 1.36-year housing land supply. You're silent on it.
I'm silent on that, yes, because I've already explained in my proof of evidence that in the absence of affordable housing, I do not see any benefit, any substantial benefit in this contributing to the high housing need. I've made the point that the housing need in Derbyshire Dales is a combination of open market and affordable housing. A scheme which does not, a greenfield site which does not contribute to affordable housing, in my opinion, goes nowhere towards satisfying the 5-year housing supply.
That is your evidence, is it? Just so that I can make a careful note of it. Your evidence is that this scheme does not make, I think you said nowhere near, doesn't make a meaningful contribution towards getting closer to that 5-year housing land supply that national policy requires. That is your expert assessment, is it?
In the absence of any affordable housing, this does not contribute meaningfully to satisfying the housing need in this district, irrespective of the enormous shortfall that there is. That is my position, my professional opinion.
And that I have noted, and I'll make submissions on that. Just to be clear about the number and the extent of the main positive benefits that we say that you have overlooked in your proof, could you kindly confirm for me that I'm right in my understanding that your proof doesn't consider any of the following? And if I'm mistaken, do tell me where I will find the reference. The benefit of housing we've already covered. Secondly, the introduction of a new sustainable drainage system to control runoff and alleviate flooding that's currently caused by uncontrolled runoff from the site and the surrounding catchments. That is not acknowledged by you, is it, as a benefit of this proposal?
No, and I do not believe it has been shown that there is any such benefit.
And that would be to relitigate the debate that we had on the last occasion, and we'll make submissions on that. But I have your confirmation that you don't regard that as a benefit, and you don't identify, therefore, it as a benefit in your assessment.
I've dealt with land drainage in my proof of evidence.
Indeed. The provision of over 10 hectares of open space, including a countryside park with improved public access to the site. You don't acknowledge that as a benefit of the scheme in your proof of evidence, do you?
That benefit will largely be to the benefit of the occupants of the houses on this estate. It would carry very little, in fact, minimal benefit beyond that, in my opinion.
Just focus on the question, please. The question was that in the planning balance, well, rather not the planning balance exercise, in the evidence that you provided in your proof of evidence, I will not find, will I, any acknowledgement of the benefit of the provision of over 10 hectares of open space, including a countryside park, whether you want to say, well, that's a benefit limited to the residents and nobody else. Well, we clearly wouldn't accept that. But even in those narrow terms in which you prefer to couch it, again, no consideration at all, or even an acknowledgement of that as a benefit of the proposal, is there?
No.
Yeah. the economic benefits of the increased economic activity in the area during both the construction and the operational stages of the development, those are not benefits that you mention anywhere in your proof, still less consider them.
Well, I take the view that the housing need of the district needs to be met, and that will generate economic benefits. I do not think those benefits will be lost by this application not proceeding, because it will mean that other sites come forward which provide just those same benefits. So there is no particular benefit from this development, in my opinion. That is a benefit that will derive from the provision of housing, and it will be a far better benefit if that provision of housing provides some affordable housing as well. Also, that benefit is over a very long term. The benefits of this scheme are spread out over 9 years. I would hope to find sites within the district where that economic benefit would be more advanced in terms of making provision, more provision in the early stages of the plan. But you will find no such acknowledgement of that benefit in my proof of evidence, because I don't think it's a benefit which derives from this particular development.
That answer takes us back in part, doesn't it, to the discussion that we had this morning about whether there is in fact another reasonably available site that could deliver this quantum of housing in accordance with, in particular, the flood risk constraints that there are in this district. That answer does not acknowledge either, does it, that this is an allocated site and that a judgment has been made in principle in the local plan, endorsed by a local plan inspector as sound, that this is an appropriate site in which to locate housing, and for the economic benefits that come with that sort of proposal to follow from the development of this site in this location. Yes?
Well, the allocation has, in my opinion, has proved to be flawed because insufficient attention was given to, for instance, flood risk. But I don't see the question you were posing was related to the economic benefits here of the construction work being carried out.
Construction and operational stages.
Yeah.
If you recall, I mentioned both. Yeah.
Yeah. As I've said, I don't see the fact that this is allocated in the local plan as having any bearing on that. What will have a bearing on the benefits from the economic activity is the actual development of site. It would seem to me that more benefits would flow from the provision or development of a series of smaller sites than will derive from the benefit of a single large site. So I don't think that's a very compelling argument, and I certainly don't see it as a benefit which needs to be weighed in the balance in favour of this development.
I have that as your clarification of your reasoning as to why you have not considered the economic benefits of the proposal at all in the planning balance, and therefore your professional judgment is that those economic benefits as we see them should be given no weight at all in the planning balance. Is that correct?
Yes.
Yeah. Mr. Yarwood, those are my questions for you. Let me just quickly check my text communications. No, those are my questions on the planning balance. I'm grateful, madam. Thank you.
Thank you, Mr. Lewis, and thank you, Mr. Yarwood. So we're now at just past 1:50. How are people placed for continuing now with Mr. Dickinson's evidence, or would you like a break, Mr. Lewis?
If everyone else is content, madam, I'm content to plough on.
Okay, Mr. Yarwood.
Yes, I'm happy to plough on.
Okay, Mr. Dickinson.
Yes, I'm fine to continue. Thank you.
Okay, thank you. So, Mr. Lewis, I'd like you to introduce the appellant's planning witness, Mr. Dickinson, and their evidence. Can I just make one point with regard to that evidence, perhaps just for my benefit? Looking at paragraph 813 of Mr. Dickinson's proof, this refers to the scheme resulting in less than substantial harm to the setting of the Grade 2 listed Wolds farmhouse. It would be helpful to me if you could, when you're taking Mr. Dickinson through his evidence, if I could be signposted to a quantification of the amount of harm on the less than substantial harm continuum, bearing in mind that the planning practice guidance advises us to do so. And I'm aware there might be recent case law as well on that. So
certainly, madam, if I could just pause for 1 minute briefly, just to, and I'll ask Mr. Dickinson to do the same. Perhaps it might be helpful, Mr. Dickinson, just to get up that planning practice guidance in relation to heritage. And
I think the relevant paragraph is within the historic environment section, and so it's 18A, paragraph 18, and the third paragraph down, it reads, within each category of harm, brackets, which category applies should be explicitly identified, close brackets. The extent of the harm may vary and should be clearly articulated.
Got it. Yep, that's really helpful.
Thank you. Over to you, Mr. Lewis.
Thank you. Thank you, Madam. Mr. Dickinson, do you need a little more time to find that bit of the PPG, or we can take a pause later to come back to it if that's helpful? I can also share it on screen.
That's fine. I've got to paragraph 18A. I'll just miss the specific sub-paragraph reference.
No problem. I've got it, and I can take you to that when we come to that part of your evidence.
Thank you.
Mr. Dickinson, given the passage of time, and in fairness to those attending virtually today who might not have been present for your evidence, I should just confirm again, you are John Michael Dickinson, Managing Director of Dickinson Planning Limited. Your qualifications include a Bachelor of Science degree, honours in Minerals Estate Management, a Diploma and Master of Arts in Town and Regional Planning. You've been a professional member of the Royal Institute of Chartered Surveyors since December 1990, and you've worked in the public and private sectors for some 35 years, dealing with a wide range of development proposals, including residential schemes. And you have a long history of involvement with this particular site, going back several years, as you tell us in paragraphs 1.3 and 1.4. You can confirm again for me, Mr. Dickinson, that's accurate and up to date.
That is correct and up to date. Thank you.
Indeed. So what I propose, given that this part of your examination in chief is focused only on this question of the planning balance, Mr. Dickinson, and we covered, of course, other matters before then. We'll also touch, in addition to the heritage question that the inspectors posed, we'll also just discuss briefly between us the implications of the sequential test work for the planning balance that you have already undertaken in your proof. Could we go to section 8 of your proof, please? Now, normally, what I would seek to do in examination in chief is not to ask you to read out evidence, but to focus on responding to contrary cases that have been made by other parties. As we've just established with Mr. Yarwood, there is no explicit commentary, of course, in his proof of evidence on the planning balance. So there's nothing in his proof of evidence per se that I can put to you to ask you to comment upon. So in the absence of that, I would suggest to you, Mr. Dickinson, that the most efficient thing that we can do, I think, in order to encapsulate your case on the planning balance is if you could I invite you, please, to read from 8.4 onwards of your proof, and I will ask some supplementary questions, perhaps, as we go along. It's essentially a page and a bit of your evidence, and that should cover the broad extent of this part of your evidence.
Okay, thank you. I have considered the effects of the proposed development in relation to a range of matters against relevant local plan policies and conclude that they would be acceptable, subject to appropriate planning conditions and/or planning obligations. Whilst there would be some significant adverse landscape and visual effects as a result of the scheme, they will be at a local level and not unacceptable, given that the principle of a residential-led mixed-use development has been established by the Strategic Housing Site Allocation under Policy HC2 of the local plan. I do not consider the proposal to be in breach of any policy in the development plan. Accordingly, I conclude that the proposed development complies with the local plan read as a whole, including in particular the Housing Land Allocations Policy HC2W and the Strategic Site Allocation under Policy DS4. On this analysis, in which no local plan is breached by the proposal, it is strictly unnecessary to ascribe weight to the various benefits of the proposed development. But I do so here for completeness, ascribing weight on the scale of significant, moderate, minor, and negligible. I consider that the delivery of up to 423 houses and a local centre on an allocated site in the local plan should be accorded significant weight in favour of the proposed development, taking into account, firstly, the government's plan for change, which promotes the building of 1.5 million homes in England over the next 5 years. And secondly, the local planning authority's extremely low, and that should say 5-year housing land supply of 1.36 years. The proposed development will provide a substantial number of market dwellings contributing to the housing land supply in Derbyshire Dales district. I attach moderate weight to the benefit of increased economic activity during the construction and operational periods of the scheme, as addressed in the revised Chapter 14 Socio-Economic Effects. I consider that the proposed new homes and local centre will be in an accessible location by sustainable modes and contribute to diversifying the market housing stock and population mix in Matlock, and accord minor weight to this benefit. I accord moderate weight to the benefit of the scheme, providing in excess of 10 hectares of open space, including the countryside park, with improved public access to land within the site for recreational purposes, along with the potential to deliver biodiversity net gain. In relation to the proposed SUDs to control runoff and water quality impacts and help to alleviate the reported flooding incidents presently caused by uncontrolled runoff from the site and surrounding catchments, I consider this will be a significant benefit in relation to the outline application part of the scheme and a minor benefit for the full application part of the site. In my judgment, the benefits of the proposed development, when considered together, reinforce the conclusion that it should be granted planning permission in accordance with the development plan. In relation to the scheme resulting in less than substantial harm to the setting of the Grade 2 listed Wells farmhouse, I consider that this degree of harm with appropriate mitigation would be outweighed by the public benefits of delivering housing to help meet the district's housing needs. I consider that the scheme would be compatible with the statutory tests in the Planning, Listed Buildings and Conservation Areas Act 1990 in relation to historic assets and accord with the policies of the local plan and NPPF in respect of the historic environment.
Just pause there, if you will, because we need to pick up on the inspector's question to us in relation to the historic environment chapter of the planning practice guidance. Would it help, Mr. Dickinson, if I shared my screen for you to see the PPG, the particular bit of it?
Yes, or you could refer to me because I've got the PPG up on my screen.
Oh, you have it. I'm very grateful. So we are looking at paragraph 18 and it's in response to the question, how can the possibility of harm to a heritage asset be assessed?
Yes.
You can let me know you're there. I'm very grateful. And so you can see there that the particular paragraph of the guidance that is relevant to this exercise is that within each category of harm, and here we are, broad categories are less than substantial harm, no harm, essentially would be the three broad categories. This is a case. Well, let me ask you to, so that I don't lead on this, let me ask you to confirm in relation to 8.13, when you are talking about the degree of harm, and indeed, yes, you confirm in the first sentence less than substantial harm. So within that category of harm, less than substantial harm, within that category, the extent of the harm may vary and should be clearly articulated. Now, the PPG, Mr. Dickinson, doesn't go on to prescribe what form that further articulation should take, but you might be familiar with the concept of a spectrum, essentially, of less than substantial harm. And sometimes, and I think it's fair for me to ask this question, sometimes the way it's put is the less than substantial harm at the upper end of that category of harm, or is it more towards the lower end of that category of harm? Is it somewhere in the middle? Mr. Dickinson, what is your judgment in relation to where in that spectrum of less than substantial harm the degree of harm would be? Is it more towards the upper, more towards the lower, somewhere in between? What is your judgment?
More towards the lower end of that spectrum of harm.
I'm grateful. And then that being so, it's self-evident perhaps, but what implication does that have for the if any, for the conclusion that you've stated in 8.13? If you are identifying the less than substantial harm towards the lower end of that spectrum, does that in any way change the evidence that you give in paragraph 8.13 when you carry out that mini heritage balance?
No, it doesn't.
I'm grateful. And if you could pick up, please, from 8.14.
As noted above, as the LPA is unable to demonstrate a 5-year housing land supply, the tilted balance in paragraph 11D of the MPPF is engaged in theory. However, I consider that it is not necessary to apply the tilted balance for the appeal to succeed, given that the proposed development complies with the development plan as a whole. For completeness, however, insofar as the inspector might be minded to consider the tilted balance in any event, it follows necessarily from my evidence in this proof that I do not consider that the proposed development would have adverse impact on the scheme that would significantly and demonstrably outweigh its benefits when considered against the policies in the MPPF as a whole. And then I conclude, for all these reasons, it is my professional judgment that planning permission should be granted for this proposed development.
I'm grateful. 2 further questions, please, just for completeness. Since you prepared your proof of evidence, the appellant, of course, with the assistance of the consultancy Marans, has prepared additional evidence in relation to the sequential test. What are the implications, if any, Mr. Dickinson, of the appellant's sequential test work for the planning balance that you have undertaken?
Based on the conclusions of the sequential test work that's been undertaken on behalf of the appellant, I consider that that the conclusions do not alter my planning judgment that the planning permission should be granted for the scheme. The Gritstone Road appeal site has been identified as sequentially preferable.
I'm very grateful. And one other question, I think, just for completeness, going back to the historic environment question again, do you happen to have on your computer, Mr. Dickinson, CD 1.3L, which is a chapter of the environmental statement dealing with historic environment matters. We might have to take a while to dig that out if you have it. If it saves time again, I can simply put it on screen.
If you wish to share it, I've almost got to that point on the CD.
Why don't I? Well, I think in fairness to everyone else present, because this isn't the easiest document to find in any event, why don't I? Yeah, I've still got the shared screen privilege. Why don't I? Here we go. Right. Okay. Now, do you see that in front of you?
Yes.
Yeah. So, is it large enough? Do I need to expand it, or can you more or less? I think it's, yeah. I hope that's.
That's fine. I'll expand my screen.
Yeah. So here we have essentially an assessment summary and residual environmental effects, table 9.5, where, and the analysis comes before it and there's some after it as well, where there is a table showing summary description of the identified impact, and we see there an entry in the yes, we see there in relation to site 7, impact on the setting of the Wolds Farmhouse designated heritage assets. And again, that features again in the next row, but not in relation to setting, but in relation to the asset itself as distinct from its setting. And we can look at that table generally to see what it tells us in terms of the detailed analysis of assessment when it comes to sensitivity of receptor, impact magnitude, and so forth. Short and simple question, Mr. Dickinson. Having been reminded of the information in this table, is the information in that table consistent with the evidence that you gave some moments ago, where you told us that the extent of the less than substantial harm that you had identified, particularly in relation to the setting of the Grade 2 listed Wolds Farmhouse, that is, to what extent is that judgment supported by the information that we see set out here in this table?
I consider the judgment is entirely supported by the evidence set out in the table, and it includes recommended mitigation measures to reduce the impact on the setting of that listed building.
I'm most grateful. Mr. Dickinson, those are my questions for you. Anything else that you wish to say on the planning balance before you answer questions?
No, thank you.
I'm very grateful. Thank you. I can stop sharing my screen. Thank you.
Does that conclude your questions, Mr. Lewis?
Oh, it does. Yes, apologies. I didn't make that clear. It concludes my questions. I'm very grateful. Thank you.
Okay. Thank you. Mr. Yarwood, would you like to cross-examine Mr. Dickinson, please?
Yes, thank you. These 423 houses, which represent perhaps the most significant benefit of the scheme, what's your judgment about the absence of affordable housing from that in terms of its impact on meeting the council's housing need, particularly in Matlock, given that the other allocated sites are brownfield sites and not delivering affordable housing? Do you think there is really a significant benefit arising from that provision?
Yes, there most definitely is a significant benefit arising from the provision of up to 423 market houses, especially taking into account the government's plan for change, which refers to promoting building 1.5 million homes in England over the next 5 years. The council's extremely low 5-year housing land supply of 1.36 years. And the NPPF also, at paragraph 61, confirms to support the government's objective of significantly boosting the supply of homes, it's important that sufficient amount and variety of land can come forward where it's needed. and that the needs of groups and specific housing requirements are addressed.
Sorry.
And that land with its planning permission is developed without unnecessary delay. We've gone through at an earlier stage in the inquiry the position in relation to affordable housing. The scheme, when it was originally submitted, promoted 30% affordable. We've since had detailed viability assessment work carried out by the appellant, and that's been tested by the council, and the conclusion of that is that the scheme cannot viably provide affordable housing. So I'm not looking to add weight to affordable housing provision as part of the planning balance.
But doesn't what you've just said say that the needs of particular groups should be addressed? This doesn't address the most needy group, which is those who require affordable housing, does it? In that sense, it doesn't comply with government guidance.
No, I consider that the scheme does comply with government guidance, because elsewhere in the NPPF, I believe paragraph 59, that allows for viability to assessments to be carried out, and for applicants or appellants to demonstrate that whether a scheme can viably support affordable housing or not.
But if it doesn't support affordable housing, it's not meeting the needs of the particular group who require affordable housing, is it?
Well, I'm not saying that the scheme will or looking to demonstrate a benefit from any provision of affordable housing on the site. There is a provision within the Section 106 agreement that if the inspector concludes a viability review mechanism is necessary to make the development acceptable, then that will provide at a later stage during the development of site for a review to see whether any affordable housing can come forward at that stage. But as part of my planning balance, I'm not trying to ascribe any benefit in relation to affordable housing.
Do you think the need for affordable housing in Matlock is less or more significant than the need for market housing?
I believe there's a need for both. There's a national requirement to significantly boost housing, and this scheme will provide 423 market houses. Unfortunately, at the present time, it's not able to viably support affordable housing.
So you acknowledge there's a need for both. So how will the need for affordable housing be addressed in terms of development in Matlock? Given that you've acknowledged there's a need for affordable housing, how will that need be addressed, given that this site provides no affordable housing and that the other major allocated sites provide no affordable housing? How does that address the need in Matlock?
Well, that's something for the emerging local plan to wrestle in terms of going forward in the future. But currently, the local plan policies that have been gone through the examination process provide a mechanism for the assessment of the viability of schemes, and where they're not viable, that can lead to either reduced or no affordable housing coming forward on site.
Do you not accept that that was a provision which was introduced because of the need for allocating brownfield sites which were more difficult to develop? It wasn't anticipated that that would be applied to greenfield sites, was it?
No, I don't accept that. The mechanism to review the viability of schemes doesn't specify greenfield or brownfield.
So do you feel that if at the time of allocation it had been recognised by the district council that none of the major sites in Matlock would deliver any affordable housing, that the council would have pursued the local plan in its current form? Would it have acknowledged that it was an acceptable situation to have the three allocated sites in Matlock delivering no affordable housing?
Without wishing to cut across Mr. Dickinson, this is not a matter within his control.
Oh, I accept that then, Inspector, yes. Moving on then. How much weight do you attach to the provision of this open space? Do you feel it would really be of, as you suggest, was it moderate benefit to the scheme? Is it not much less than that, given that it's primarily there to serve the needs of the development which will take place here?
I disagree with that. I've attached moderate weight to the provision of open space, which will be available for residents who live on site, but there's also a number of access routes that will be available for existing residents immediately to the south. We've also provided or proposing a link to Sandy Lane to the east of the site to join an existing footpath. So I believe that the scheme will be an attractive place for people to visit, both for those residing on the site and from further afield.
But none of that provision is made in the full planning application, is it? It's in the outline application, which is some years down the line.
The open space does include areas in and around sustainable drainage, attenuation measures, and there are additional areas of land that will be available for the pedestrian link to Sandy Lane that's coming forward in phase 1.
The open space doesn't come forward in phase 1, does it?
I accept that the bulk of the open space comes forward as part of the outline scheme, including the countryside park.
Having heard the evidence that's been given during the public inquiry, do you still feel that the issue of controlling runoff is indeed still a benefit, or has any of the evidence persuaded you that that benefit may not be as significant as you might have anticipated?
I consider that the benefit of the scheme attenuating flows from the upstream catchment and releasing that in a controlled manner will assist in alleviating current flooding issues downstream of the site, and I consider that to be a significant benefit that weighs in favour of the scheme.
No further questions. Thank you.
Thank you, Mr. Yarwood. Just I'll open the floor to others, but just a question from me, just picking up on that point, Mr. Dickinson, that Mr. Yarwood's just asked about the sustainable drainage. At 8.11 of your proof, you refer to it being a significant benefit in relation to the outline application part of the scheme and minor benefit for the full application part. If I were to have any concerns about the sustainable drainage proposals within the proposed development, can that sustainable drainage still be given weight as a benefit in my balance?
If you had concerns, I suppose it's the extent to which, or the weight to which you would attach to those concerns, but based on the evidence from our drainage expert, I consider that a significant weight can be given to the benefit.
Thank you. Are there any questions from any interested parties who are objecting?
Yes, I'd like to ask Mr. Dickinson somewhat similar to what you've asked. With the pattern of weather changing and becoming more wet, and as we've seen in Britain last year, heavy rainstorms got stuck and poured their rain, flooding the A14 for a number of days. It was very fortunate it didn't hit Matlock, but probably would have been fortunate if it had. The parties might have seen what worries residents. How would you feel that the pattern of cascading suds would handle being filled up one day, maybe draining a little bit, and then the storm reappearing and getting stuck to the point where it overtops them all? Would you think the suds would survive? If they don't, where does the water go?
Mr. Dickinson, I'm not sure whether you're going to be able to answer that question.
I was simply going to suggest that matter's being dealt with at an earlier stage in the inquiry, and I'm not the expert drainage witness. So it's been covered previously.
Film, you might concern you.
Mr. Ashby, it might be helpful to you in terms of getting a response to that question if you look at the evidence of Mr. Hilton, which is available on the videos, because he was asked questions about the cascade of basins and storm duration.
Yes, my asking again indicates I did hear it, and whether we believe it remains to be seen.
Yes, the difficulty is that you're asking Mr. Dickinson, who is here to deal with planning evidence, and Mr. Hilton was available earlier in their inquiry. Are there any other questions which relate to planning evidence? No? Okay. Thank you. Mr. Lewis, would you like to re-examine Mr. Dickinson, please?
I've no re-examination, madam. Thank you.
Okay, thank you very much. Thank you very much, Mr. Dickinson, and Mr. Yarwood as well. So we're now at 2:25.
Sorry, I'm so sorry. I think the raise hand function is not working, so I couldn't.
Okay, no worries.
Forgive me for interrupting you. There was really just one of the issues you raised at the outset was about heritage. It's really just a point for your note. I hope to assist. There are two references you might find useful. One is the statement of common ground between ourselves and the appellant, which is CD 8.1, paragraph 511. Now, that doesn't take matters much further because it just says this agreement is to less substantial. But the second reference is in the committee report where there was an analysis, which is CD 4.2. So if you'll note, CD 4.2, paragraph 7.111, which is PDF page 113. And there is a bit of analysis on the farmhouse over a number of paragraphs. In that paragraph, there's a conclusion that it would be less than substantial harm at the lower end of that bracket. So if you wanted a reference of analysis,
thank you.
From the council's perspective, that's where you find it. Thank you.
Yeah. Thank you. I had already spotted that the statement of common ground didn't take us very much further, but absolutely, CD 4.2, that's very helpful. Thank you, Mr. Cosgrove. Okay, so unless there's anything else in terms of procedural matters or housekeeping at the moment, should we take a break and come back? I've got Mr. Wayne. Sorry, Councillor Wayne. Got a hand up. The hand up's finally working.
That's fortunate. I'll try and get the video on as well. Thank you. Okay. Thank you. Apologies for this morning. I couldn't get an elderly, poorly mother, I'm afraid. But with not seeing anything this morning, I just want to clarify a point, if I may, and it may already have been raised, and please tell me to shut up if it has. But on the phases 2, 3 and 4, you recall, Inspector, when we went for that promenade through the fields on the site visit, and we walked back along Cavendish Road, and I pointed out where the connection was going to be at the bottom of the car park for the attenuation basins. And I also advised you that there was some issue, well, as to ownership of that property, and that William Davies had made an approach previously. Now, without that connection for phase 2, 3 and 4, would those additional sections to 2, 3 and 4 be able to go ahead? Would it be able to be delivered if that connection wasn't viable? That's what I was going to ask Mr. Dickinson that, but if it's already been dealt with this morning, then that's fine. But I just have a concern regarding that. Thank you.
Mr. Lewis, did you want to pick that up at all?
I will speak to my team about. I wasn't at the site visit. I know of the particular part of the area that you're talking about at Councillor Wayne, but I haven't been privy to any further, more recent discussions in relation to that particular point. I will turn to Mr. Dickinson because he perhaps has more of a familiarity with this issue in recent weeks, but Mr. Dickinson, you might not either. If not, then I will certainly make inquiries and come back to you, Councillor Swain, with a response on that.
Mr. Dickinson.
Yeah, we may need to take soundings from the client, but as I understand it, just provisions under the Land Drainage Act to enable a connection to be made to the existing drainage system from the site.
It would probably be helpful, just in order to be clear to Councillor Wayne that a response has been made, if the appellant could look into this matter and perhaps provide me with a note which can then go on the inquiry website so it's accessible to everybody, including Councillor Wayne, to just clarify the situation. Because, Councillor Wayne, it wasn't something that came up this morning.
I'm grateful, madam. Now, I just want to just clarify one thing, because I wouldn't want anything to progress and then find out that there was a stumbling block with the access, because I am aware that the land is currently being sold and has a prospective buyer, because I was at a meeting the other day in relation to this, and I'm assured that it isn't William Davies. So it's the access to it. But thank you very much, and I'll try and shut up now. Thank you.
Thank you. Mr. Lewis, any indication as to when you might be able to provide that note? We're looking at closings on the 15th.
Indeed. We will certainly be able to do it before then. I mean, my intention at the moment, I'm fairly advanced in the drafting of my closing, and there is some coverage of Land Drainage Act provisions in that closing, madam, so that it might be that the point will certainly be fully answered then. But let's do it before then to give interested parties any reassurance that we can provide about that point. So can I suggest, madam, what is it today, Friday, that we will aim to get a note clarifying the position in relation to that matter by next Wednesday?
So we're looking at the 9th.
Looking at the 9th, yes. I'm sure that we'll be able to do it more quickly, but just in case there's an issue with availability and so forth, and in case we need to make any inquiries, and I can see from messages that my team is sending that they regard this as something that will be straightforward to explain. Okay. I think we can safely say that by Wednesday next week at the latest, we will provide something, and earlier if we can.
Thank you. That's much appreciated, and hopefully that will put Councillor Wayne's mind at rest on that point. Okay, thank you. So, shall we take a break until 2:45 and then come back for conditions and obligations?
Certainly.
Okay, thank you. So the inquiry is adjourned until 2:45. See you all soon. Hello, the time is 2:45 and the inquiry is resumed. Okay, so we have dealt with all of the remaining evidence. So I just wanted to turn to have a further roundtable on any outstanding matters relating to conditions and planning obligations. And if I could just make a start with the situation of planning obligations, I don't have any changes that I'm suggesting to the latest draft of the legal agreement that I've been sent, which is ID 38. But I did want to understand what the situation was with the legal agreement in terms of timing of being signed off, or whether there were any outstanding issues with the legal agreement. Mr. Lewis.
Madam, thank you. I'm pleased to see that Miss Saffa is on the call and will be able to help us, I hope, with that state of affairs. I know we're in a good place, but Miss Saffa will be able to expand on that.
Thank you. Hello, Miss Saffa.
Good afternoon, Madam. The Section 106 agreement has been sent out for signature. I've liaised with the solicitors acting for all the landowners, and there is a sort of schedule in place, as it were, for each set of solicitors to liaise with the next set of solicitors and forward it on. It will then go to my clients, onto the county council, and then finally end up at the district council for sealing and completion. But I do anticipate that that is going to take probably at least 3 to 4 weeks. I'm slightly dependent on the signatories available when the documents land with their respective solicitors. So I'm not quite sure how you'd like to deal with this. I can, of course, keep you updated. But even once the document gets to the county council and then the district council, they have set sealing days each week. So if we've missed the particular sealing day in a given week, then we need to wait until the following week before we can ensure the document's sealed with each respective local authority.
Okay. Just thinking about your 3 to 4 week time scale.
Might be slightly optimistic.
Keeping your fingers firmly crossed at the same time as saying it. Just so that you can understand where I am in terms of hopefully completing the decision and being in a position to issue that decision. I will be in the office until the end of the 25th of July, and then I will be out of the office until the week commencing the 11th of August.
Okay.
So if it should miss the 25th of July, you would be unlikely to hear anything about the decision until
Understood.
That Understood. Week of the
11th. I will do what I can to have a completed document with you before 25th of July. I think rather than giving you blow by blow updates, probably the sensible time for me to update you is once it's been signed by the 3 landowners and my client, and is then with the county council. Once it's with the county council, I'm going to have a much better idea of when completion is likely to take place.
Yeah. Okay. So it would be helpful to me to have an update before the 25th of July in any event, as to where matters are, but it would also be helpful to understand when it has gone from your client and the 3 landowners to the county council.
Absolutely.
Okay, so if you could keep in touch and copy that into all the relevant parties, that would be helpful.
Of course.
Okay, is there anything else on the legal agreement from anybody? Nope. Okay, thank you. Shall we move on to conditions? Thank you, Ms. Saffa. So there is a document which was circulated on the 26th of June, which is ID 42, which was a slightly cleaned up version of conditions. We also have ID 40, which is draft conditions on the 25th of June with a lot of track changes. And we have ID 41, which is the Wolds Action Group comments on the conditions, which I also have before me. So what my intention was to go through the conditions again and just pick up on any points which are still remaining outstanding. So basically, please put your hand up or shout out if there is any remaining issue. So anything with condition 1? No. Condition 2. And condition 3, which is the plans condition for the full planning permission. Okay, condition 4, which is the plans condition for the outline. Mr. Yarwood. I think you're on mute, Mr. Yarwood.
There still seems to be a disparity between the heading and what it says the development is in condition 5, because the heading says and/or a hot food takeaway, whereas this even as altered, it doesn't say and/or takeaway. Well,
So we moved on to condition 5 here, is this?
Sorry, yes, I thought we were there. I apologise.
Okay. Okay, so your concern is the how this reflects the description of development.
Yes, and/or in the now the description of development in the heading seems to have changed to and/or food takeaway, but that still doesn't seem to be reflected in any of the amendments.
Can the appellant assist with this at all, Mr. Dickinson?
Thank you, Ma'am. Just for a quick bit of background, the reference to 234 square metres gross place of use class E floor space and 116 square metres for the takeaway stemmed from the planning application form, and that's reference CD 1.1 within revised ES chapter 4 at paragraph 4 to 15, and that's CD 261F. That referred to providing a gross floor space for class E and sui generis uses, hot food takeaway, of 350 square meters. So what I was going to suggest is potentially, rather than specifying floor spaces for the class E and then a separate floor space for the takeaway, it may be better refer to 350 square meters gross of use class E and of sui generis takeaway. And then Mr. Yarwood, in his evidence, raised a point about whether in accordance with the MPPF it's appropriate to have a takeaway within a walking distance of schools, etc. And so I assume that you will take a view on that. So if we refer to 350 square meters, if you consider a takeaway is inappropriate, then that can just apply to the class E floor space.
Mr. Yarwood, any views on that?
No, as long as what's put in the conditions matches what's in the heading, how it's done, I'm no concerns. It's just that the heading and the condition should refer to the same development, and so if it's and/or a takeaway in the heading, perhaps that needs excluding based on your judgment as to whether a takeaway is appropriate or not.
Okay. Anything from the council on that point?
I think the council's view is that it is necessary to restrict the floor space of class E and/or takeaways just to meet the requirements of policy DS4 of the local plan, which is the allocation policy, which does say that the local centre uses should be of an appropriate scale. So I think that's the key factor, is we just need to limit the upper threshold of floor space so that it's in accordance with what's submitted, and there is a degree of control in establishing the principles of what may be approved.
Okay, anything further from the appellant?
No, Mark, thank you.
Okay, I'll take those thoughts away. Okay. Anything on condition 6, which is about scale, layout, external appearance, access, etc.? No. Condition 7, archaeology. No. Condition 8, which is the construction management plan for all phases. No. Condition 9, I think you'd raised a point on this, Mr. Yarwood.
Yeah, actually, looking at it, occurs in condition 8 as well. It's not a point I'm very concerned about. It just the condition which says that something shall be approved in writing by the planning authority, it doesn't seem to give the planning authority any scope to do anything other than to approve what's put in. I would have thought the wording which development shall not commence until something is approved is a better wording than simply saying that something shall be submitted and approved by the planning authority. I'll leave it with you. It seems to me it's a minor point, but in terms of good drafting, it just seems to me that the planning authority should be given some discretion not to approve.
Any comments on that from the council?
It's standard wording, and it's within the gift of the council to not discharge the applications if they feel appropriate.
Okay. Anything from the appellant?
I'd agree with Mr. Instone's comment. Thank you.
Okay, thank you. So that's obviously you pointed it out on condition 8. It's also on condition 9. Then we have condition 10, which is about badger mitigation. Anything on that? No. Condition 11, which is about the construction environmental management plan biodiversity. Mr. Yarwood.
Very minor point, but it just seemed to me that since it says no development shall take place and then includes things which are not development, so I would have thought it should say no work shall take place, but it's not I don't want to labour the point.
Okay, thank you. Anything from the council on that?
Yeah, I mean, that's actually clarifying that in this case, development is beyond the statutory definition in the Town and Country Planning Act, and includes demolition and vegetation. So it's actually confirming no works at all can take place is a word in that condition, rather than in accordance with the legal definition of demolition, which it adds additional protection.
Okay. Anything from the appellant on that one, Mr. Dickinson?
In order to address Mr. Yarwood's point, you could potentially, after phase 1 of the development, add all works and then go on to including demolition. I know the next one says groundworks, there's a bit of duplication, but that would cover development and the other work specified.
Okay, thank you. Mr. Lewis appears to have disappeared. I'm wondering whether that's a good disappearance or a bad disappearance. Obviously, conditions are a very exciting topic for late on a Friday afternoon, but if he's just lost connection, it would be helpful to understand. Ms. Saffer.
I will contact him and find
Yeah.
out. I know he does have trouble with his Wi-Fi, and I don't think there's any witchcraft at play and that he's disappeared, but I will try and find him as soon as
It's
possible.
just I don't want him to miss the sheer excitement of conditions.
sure-
He doesn't
I'm
want
sure
to.
he wouldn't want to miss it, but let me try and track him down.
Okay, thank you. We'll carry on in the meantime. I'm sure he can come back to something if he's very concerned about it. Okay, so condition. Mr. Lewis is back. We were wondering whether you had a
Apologies,
Wi-Fi
everyone.
problem or you just got.
My connection froze temporarily, but I'm back now. I'm assuming that I didn't miss anything significant, madam, but you'll tell me if I did.
No, we're on condition 11.
Grateful.
Which
Thank you.
I'm not quite sure when you disappeared, but thank you for confirming. Okay, anything further on condition 11? No. Condition 12 is about a bespoke compensation plan for the translocation of rush pasture. I have to say that very carefully, within phase 1. Anything particular on that one apart from the submitted to and approved in writing point? No. Okay, condition 13. This is about a landscape and biodiversity enhancement and management plan. Again, the same point about submitted to and approved in writing. Anything further on that one? No. Okay. And it's a long one. Condition 14. Similar issue in terms of submitted to and approved in writing, but anything else? Everybody happy with the plan numbers? Yep. Okay, thank you. Then condition 15. So this is the condition regarding the pedestrian crossing on the A632 Chesterfield Road. Obviously, I understand that the Moles Action Group maintains its opposition to the movement of the crossing and the positioning of the proposed new crossing. But anything further on the condition as a condition? No. Okay. Condition 16 is about highway improvement works, road widening, etc. And that's submitted to and approved in writing. But is there anything further on that particular condition? No. Condition 17. So this is about it's a very detailed condition in terms of detailed design, associated management and maintenance plan of surface water drainage. Any concerns about the wording of that? Mr. Yarwood.
I made a point in my comment, but it's not something I want to labour particularly. I've drawn it to your attention as a possible alteration. But
so this is about moving. So the 4-season flow monitoring shall be carried out over a 12-month period to inform the detailed design of catchment-related runoff.
But rather than just a statement, as it were, at the end of the. Doesn't seem to have much place at the end because it doesn't seem to require anything other than arising from the 4-season monitoring, if you see what I mean. It requires it, but doesn't conclude what it's for or how it's going to be used. Whereas if it appears in the way I've suggested, it has some greater meaning, I think.
Thank you. Anything from the council on that?
I think the criteria in F is adequately precise in terms of 6 tests. It's clear what's expected. And I think, when the paragraph's read as a whole, I think it will be evident of what the council's expecting.
Thank you. Anything from the appellant, Mr. Dickinson?
I'd agree with Mr. Instone's comment on this one. Thank you.
Okay, thank you. I'll take that away. Condition 18. So this is residential design code. And so how will that be approved?
Well, I was going to suggest that at the end of the first sentence, after subsequent phases, we just add and shall be submitted to the LPA for approval in writing. And then there's already a sentence at the end of the condition that deals with carrying out developments in accordance with the approved details.
The approved design code, yeah. Anything else on that particular condition from Wells Action Group or the council?
Well, that would address the concern I raised, I think.
Okay, good. Anything from the council, Mr. Instone?
Yeah, I suppose the wording of the condition at the moment is it's really expecting the design code to be submitted alongside the reserve matters. So we're not necessarily, because we'd expect it to be prepared sort of concurrently. So it's not really something that would need to be submitted and approved beforehand necessarily. So it's just, you know, just showing there needs to be a sort of comprehensive process when submitting the design code, which should inform the reserve matters. So I suppose the wording as drafted was, you know, I think it was on the assumption that you may get the design code at the same time as the first reserve matters and allowing for that. But, you know, I'm happy to accept, you know, whatever revisions you consider necessary.
Okay, thank you. Anything further on 18? No. So condition 19 is about details of layout and access roads, visibility displays, width, speed management features, etc. Anything on that condition? No. Condition 20, each reserve matters application shall include details of existing and proposed ground levels, etc. No. Condition 21. So this is reserve matters for phase 2 shall be accompanied by design and management and maintenance plan of surface water drainage. And again goes into similar detail to condition 17. Anything further on that one? No. Condition 22. So this is the multiple risk assessment policy with regard to the basins within the country park. Mr. Yarwood, did you have a concern about this one?
My only concern is that it says that if the risk assessment demonstrates an acceptable risk, they'll carry out another risk assessment. It just doesn't seem logical to me, but I can't improve it or alter it.
Okay, anything from the council on this one? No. Mr. Dickinson, anything from the appellant?
No, I consider the wording works fine, thank you.
Okay, and then condition 23 is about phase 2 or any subsequent phase in relation to construction environmental management plan on biodiversity. Anything on that one?
I made the point I made earlier that since some of the so-called development is not development, it should perhaps say no works, but not a point I want to labour again.
Okay. 24 is the translocation of rush pasture for phase 2 or any subsequent phase. Anything on that one beyond the submitted to and approved in writing? Nope. 25. This is the landscape and biodiversity enhancement and management plan for phase 2 and each subsequent phase. Anything on that one? No. 26 is about a scheme of hard and soft landscaping to be submitted. Mr. Yarwood, did you have an outstanding concern on this one?
On which one? Sorry, I've lost the thread for a moment there.
This is condition 26. So this is about hard and soft landscaping for phase 2 and each subsequent phase of development.
No, there was no indication of timescale for implementation in the condition. The other comment has been addressed in your revision, I think.
Council got any comments on that?
Yeah, I mean, there could be a clause in there about timescale for implementation, but to be honest, I would expect the planting plans submitted to discharge it to include that as standard anyway. So the planning authority could ask for that details during submission anyway. So yeah, I'm happy with the wording as suggested, but we could include an additional clause just requiring timetable for implementation.
And any views from the appellant?
We have no objections to the inclusion of a clause relating to as part of any submitted scheme to include a timetable for implementation.
Just scribbling. Thank you. Okay, moving on to condition 27. So this talks about the housing mix. Anything on that condition? Nope. Condition 28. So this is details of phasing of the housing and delivery of the Class E and sui generis uses. Obviously, there's the submitted to and approved in writing, but anything else? No. Okay. Condition 29 is about the timetable for the delivery of the link road and it being in operation prior to the 151st dwelling being operated, being occupied on site. Sorry. Anything on that one? No. Condition 30. So reserve matters for any use Class E or sui generis takeaway use. This is the noxious odours condition. Anything on that one? No. Okay, condition 31. So this is for reserve matters for phase 2 and each subsequent phase of development shall include drainage plans for the disposal of foul sewage. Anything on 31? No. Okay. Condition 32 requires a verification report by a suitably qualified independent drainage engineer. Anything on that one? No. Condition 33 on bicycle parking. No. Condition 34. So this is a hours of operation condition. So no machinery except between 8 AM and 6 PM Monday to Friday and 9 till 1 on Saturdays, and nothing in terms of deliveries before 9 or after 3 Monday to Friday and so on. Any comments or concerns about this condition 34?
Just that if it's been modified to protect the interests of children attending the school, that should appear in the reason, I would have thought, but it's not a major issue.
Okay. Anything else on this condition? No. Councillor Wayne.
I don't know if I'm allowed, madam, but is a Monday classed as a Monday if it's a bank holiday? People are going to want some peace from all this development over a bank holiday weekend. but the developer may think that a Monday is a working day. So I was just a Monday. Thank you. Just wish to raise that. Thank you.
The final sentence of the condition reads, no construction work or delivery shall take place at any time on Sundays and bank holidays. So hopefully that matter is sufficiently covered.
It is now, so I apologise for that.
No worries. Thank you. Okay, anything else on 34? Right, and condition 35 is about lighting strategy and lighting fixtures. Mr. Yarwood, did you have a concern about this one?
Yes, just that it doesn't seem to me that it can apply across the site, because once residents move in, they're not going to be submitting details of lighting. So it ought to relate to the lighting of public spaces, I would have thought, unless individual residents are going to have to apply every time they want to put a PIR light up on the house.
How does the appellant see this condition working?
The scheme that the developer would submit would relate to lighting fixtures within the public realm, and I suppose if there's any external lights to be fitted to the houses when they're built. So I think the wording is drafted should be fine. I appreciate, once a house is sold, residents then may bring forward, additional lighting on their properties. So I don't know whether we need to try and sort of focus down the condition slightly so that it relates to what the developer is going to install and approve. Install following approval.
Mm-hmm. Anything from the council on this one?
Yeah, so I would expect, usually the case, when the lighting strategy is submitted for discharge, it would have all details of lighting and direction in the public realm, and maybe you could sometimes they have a sort of generic statement, and within people's residential gardens adjacent to houses, the lighting luminaries won't go above a certain level. And I think, if at some point in the future that somebody, for instance, put a floodlight in their garden, there would still, the planning authority would still have the ability to take enforcement action under the requirements of the planning condition. But I think the lighting strategy would generally provide a generic catch-all within reasonable parameters for the residential gardens.
Okay, thank you. Well, I'll take that one away. And then finally, conditions 36. So this is the condition regarding the discovery of any further watercourses, springs or groundwater were not previously identified, and requires an assessment of risk and mitigation of that risk. Any comments on that one? No? Okay, thank you. Well, thank you very much for that input on conditions. Anything further on conditions before we adjourn for the day?
I did make a couple of comments that there doesn't seem to be a requirement for implementation timescale for any landscaping on phase 1. At least I haven't found any. So although landscaping is shown on phase 1, there's no timescale for implementation.
Mr. Dickinson?
Okay, condition 3 deals with the drawings to be approved for hard and soft landscaping. And then condition 13 deals with the biodiversity or BEMP. And as part of the submitted scheme, that can cover off timescale for implementation and then maintenance of any planting that fails.
And does that also cover off the concern that Mr. Yarwood raised with regard to protection to badgers and birds and other wildlife? That condition 13.
Yes, condition 13B provides for habitat enhancement for wildlife as part of the BEMP on phase 1, and condition 25 deals with it for phase 2. So within habitat enhancement for wildlife, I think that will cover protection for badgers, birds, etc., and reptiles.
Okay. Anything further on that, Mr. Yarwood?
No, I've made the point. I'm happy with the explanation.
Okay, thank you. Any further procedural or housekeeping matters before we adjourn?
Just a quick matter to check, Madam, for your preference for the protocol for the closing submissions session, because we're doing it virtually. Is it your preference that we all email our closings to you before the session starts, Madam, or should we do it just immediately before we're about to read our closings on the day? Clearly, we will do whatever you prefer.
Okay. My preference is that I can have it each closing at least 10 minutes before it's due to be delivered, so that I can print it off and scribble on it if you do make any changes. So for the Wolds Action Group, that would mean that it would be provided to me before 9:30 on the 15th of July. And then for the council, if they can provide it to me at least during that first session, that's helpful. And then the appellant should provide it in the break before session 2. Yeah.
Will do. That's very helpful. Thank you very much.
Okay. And those will then go onto the inquiry documents library in due course. So in the meantime, it would be helpful to have that note that we've agreed to be provided by the 9th of July. And it would also be helpful, obviously, with SAF is going to keep me informed in terms of the progress of the 106. And otherwise, it looks like we don't need the Wednesday the 16th unless something untoward occurs, which I obviously hope in terms of everybody delivering closings doesn't occur. But so we're looking at Tuesday the 15th for closings. Anything further before we adjourn for the day until we come back on 15th?
Nothing from us. Thank you.
Okay, well, thank you very much, everybody, for your participation today. It's 3:23 and the inquiry is adjourned until the 15th of July at 9:30.
Thank you.
Have a good weekend. Bye-bye.
You too, Madam. Thank you very much. Thank you.
Bye.